In the days since the remnants of Hurricane Ida swept through the Northeast, killing 45, and ISIS-K in Afghanistan killed 13 Americans and many more Afghans, many have argued these were disasters we should have seen coming. And then there's the Constitution upending case in Texas that many did see coming from hundreds of miles away, literally. As of last Wednesday, it is illegal to get, give, or in any way at all help a person obtain an abortion after 6 weeks in Texas. That's after the Supreme Court refused to block a new state law. And as the conservative majority on the high court opted to look the other way, a chorus of "I told you so's" rang out, including from the New York Times editorial board, which declared the move stunning but not surprising, given nearly a half a century of, quote, constantly chipping away at women's rights to an abortion, which includes Donald Trump's 3 pro-life appointees. Instead of giving government officials the power to stop abortions, this law puts the power in the hands of private citizens, letting them sue anyone who gets, gives, or helps with an abortion, and they get $10,000. Those are called bounty hunters. And while the court could still take up future challenges to the law, Joe Biden is promising to do all he can to stop it on his end.
The most pernicious thing about the Texas law, it sort of creates a vigilante system. I was told that there are possibilities within the existing law to have the Justice Department look and see whether are there things that can be done that can limit the independent action of individuals in enforcing a federal system, a state law.
Joining me is Suffolk University constitutional law expert Renée Landers, who's on the Planned Parenthood League of Massachusetts board. Renée, good to see you. Thanks so much for being here.
Thank you for having me, Jim.
You're quoted in the Boston Globe of saying it's hard to say what the Supreme Court is ultimately going to do. But if 5 justices allow a law to continue in place that makes illegal an act that was constitutionally protected for 50 years, why should we not assume that they're intending to permanently do what they have already temporarily done?
Well, I like to give the court the benefit of the doubt, and I think that what the positive aspect of what they did, and there are very few positive aspects, is that between now and when the court will hear the arguments in the Mississippi case, make a decision in that case, which also raises a similar issue, although the restriction isn't quite as severe, the court will see what has happened in Texas. And I think that will give them information that they could have waited to receive from, further litigating the case. But and that might cause them to take, I'm not saying that they won't restrict access to abortion further, but it might cause them to take a more incremental approach than, jettisoning Roe v. Wade.
I hope you're right, but you don't need to be a Supreme Court justice to know what kind of harm is going to happen if you essentially ban abortions, which is virtually what they did in Texas. And there are many cases with these midnight docket things they do where they have said, oh, no, like religious expression cases in the last year around things like COVID. And the New York Times, the Washington Post did a great editorial saying if New York or California passed a law banning guns, do you think they would have said, we'll take a pass on that and we'll decide it when the case comes to it? So once again, I read much more into this unsigned ruling than you do, apparently, yes?
Well, I guess that I would say 2 things. One is that Chief Justice Roberts' dissenting opinion in this case on the Texas abortion law pointed out the need for the court to tread very carefully in these areas with these old precedents. I think he is very concerned about the institutional reputation of the courts. And, these examples that you cite, I think, give him pause, because then the court just looks like another political arm of the government, as opposed to, an institution that's supposed to respect precedent and, rely on the rule of law. And so the second point I would make is that perhaps he has the opportunity to persuade at least one of his other colleagues who, voted in this case to take a different position.
Once again, I hope you're right, but it seems to me, understanding how decisions are parceled out that when the Chief Justice is in the minority, as he is here with the three liberals, the de facto Chief Justice becomes the most conservative man on the court, Clarence Thomas. He is the de facto, at least in this case for the moment, and going forward where Roberts is not with the majority, he's the de facto Chief Justice, is he not?
Well, he would be as the senior justice who might be voting on that side of the equation.
You know, the department, one of the great ironies of this is Merrick Garland, who is now the Attorney General, who would have been sitting on this court if Mitch McConnell cared about justice. Instead, Neil Gorsuch is sitting on that court. He said he will protect women. His words was protect women who are seeking abortion in Texas. But I assume that means only protecting from physical violence, for example, if there is any at a Planned Parenthood, for example, because essentially they have no right as of this moment to be, quote, protected as goes their right to choose, correct?
Well, and another thing that we should consider in that regard is that, the Attorney General, Merrick Garland, he did put out a statement recently where he pointed out that there is a federal statute, right, that prohibits people from interfering with access to reproductive health care clinics and services. So I think that, yes, physical violence would be one aspect of that, but also just, interfering with people, getting into a parking lot or any of those sorts of things. Second, one of the features, the unique feature of this Texas law is that it tries to outsource enforcement of the law to private citizens.
Right. Bounty hunters.
To bounty hunters, right? To try to, in an attempt to insulate the law from being challenged, because the theory would be that it's not the government that's prohibiting, that's interfering with the rights of women to access abortion services. However, from dating from the civil rights era, there are other federal statutes and doctrines that say that, really the government's ability to outsource a traditional public function like enforcing the criminal law is limited. And so that's another legal avenue for trying to challenge what Texas has done here.
We should make clear to people who are not deeply involved in these issues is that even if the worst were to come from the Supreme Court, it would not ban abortion across the country. It would leave it, it would say it's not protected by the federal Constitution and be left up to states. On the good end, places like Massachusetts. On the bad end, some of the southern
right, and there are more than a dozen states, right, that have laws ready to go if that should happen. So it would have an impact beyond just a state like Texas or Mississippi that has the current case pending before the court.
I want to play
but
for you.
But it would not affect what's going on in a state like Massachusetts.
Understood.
Exactly.
Several years ago, actually the night before the New Hampshire primary in 2016, a candidate, Donald Trump, joined Marjorie Egan and me on our radio show, and I think we were the first people to ask him if he had a litmus test for Supreme Court nominees. Here's what Trump had to say.
We want good, strong, conservative people that are extremely smart. I'm pro-life, and I would put in pro-life.
Yeah, so he clearly knew what he wanted, and I bring that up because I want to know if you think this puts pressure on Stephen Breyer in his 80s to do what he appears not terribly interested in doing, which is stepping down at a time when a like-minded president could name a replacement and not repeat, and it's hard to ever criticize her, what Ruth Bader Ginsburg chose to do, and we saw what happened there. Do you think it does increase pressure on Justice Breyer?
I think he does feel the pressure. I mean, I think he's aware of what people are saying and what the politics of the situation are. If we were at a different time, you referenced Justice Ginsburg. I mean, when she was nominated to the court, she was confirmed 97-3 or something like that. And if we were living in a time like that, where really quality people could get confirmed regardless of their political views or their, positions they've taken on issues, then his position, I think, would be reasonable. But I do have a concern that he will overstay, and then the timing could be bad for nominating and confirming a replacement who would, take his ideological positions on the court.
Well, he lives right across the river. I hope he's paying attention. Renée Landers, it's good to see you. Thanks so much for your time.
All right. Thank you for having me, Jim.